All right, thank you. And by way of introduction, I'm Mike Steenson, and I'm a professor at Mitchell Hamlin School of Law, and I have the privilege of being the faculty advisor to the Law Review. Before I start, be sure that you understand that what I'm going to talk to you about is not a set of absolute rules, but really things that you might think about in writing, things that have worked for me. But like any advice that you get, and you get a lot of advice as law students, take what you think is going to work for you, make it your own, and don't try to adhere to somebody else's template. So you'll be writing for volume 51 of the Law Review, and I thought it might be helpful to put up just an outline, and I'll get to that in just a second, of a published case note. Another one will be published fairly soon. We were talking about that just a couple of minutes ago. Carissa Hanson's case note is going to be published in volume 50, and we think it's going to be in maybe the first week in May. Actually, we both have an article coming out in that same edition. So that will be another article that you can take a look at to get a really good idea of how a good case note is written. All right. Now, some of you are tuning in, I think, probably because you're not really sure whether you should try this. You don't know. You might be a little bit apprehensive. You're not sure how much work it's going to be. So these are key questions. Can I do this? And do I have what it takes? And I think the short answer to both of those questions is yes and yes. You wouldn't be in law school. You wouldn't have successfully almost completed your first year if you didn't have what it takes. And honestly, I think that the key to law review success, and I doubt very much that anybody would dispute it, is just simply the willingness to do hard work. You've got a limited amount of time to write the case note, and I think it's really important to get going immediately once you find out what the case is that you're going to be writing about, and once you get the materials. So get started right away. And I think the most important thing is just to put in the time, and that's really, really important. Now, this is an example of a published case note from volume 49, and for volume 49, the write-on case was Staub versus Myrtle Lake Resort, and it was a case involving a causation issue. The woman fell down some steps and died as a result of that fall at Myrtle Lake Resort, where she and her husband actually worked. But there was limited evidence of causation. The plaintiff's theory was that deficiently constructed and maintained steps was the reason for the fall, but nobody actually saw the fall. So the case dealt with causation. Haley Ostreicher wrote that case note. And this is the table of contents for the article that she wrote. She started with an introduction and then a history of the case, and then getting her history underlying the causation issues, and then the Staub case itself, facts and procedural history, and then the Minnesota Supreme Court's decision, and then she got into the analysis of the causation issue. It was a well-written article. Now, if you're thinking, my God, would I have to do this in the draft that I turn in? Well, no. Keep in mind that Haley's case note was selected as the case note out of all of the case notes that were submitted, was selected as the case note to get published. And so it underwent lots and lots of changes. So she worked with a faculty member, and she worked with editors on the Law Review. So it went through a pretty significant editing process. So I would suggest that you read this article, read Carissa Hanson's article when it comes out, But once again, don't assume that this was anything like a first draft. It wasn't. But this just gives you sort of a general outline of the things that you should be considering when you write the case note. And I think you'll probably get a similar template from the law review once you get the case and once you start writing. All right, so getting started. The first thing you do, of course, is to read the case. And this sort of reminded me of something that my contracts professor always drummed into our head. He'd say, what's the first rule of statutory construction? And we, of course, not know what he was talking about. He'd say, well, it's to read the statute. What's the second rule of statutory construction? It's read it again. Well, it's the same thing with a case. And you've all read lots of cases now in a lot of different areas of the law, including some really complex constitutional decisions. And so do what you do with any case. If you're having potential difficulties, you read the case, then you read it again. And maybe you need to read it yet a third time and a fourth time. And with a case note, you'll end up reading it quite a few times as you do your research and consult the sources that you're provided with, or the law review provides you with. All right, so you want to make sure, just like you were doing a case brief for torts or contracts or property, you want to make sure that you understand what the case is about. You want to make sure that you understand what the procedural posture is of the case. You want to understand what the key issues are that the court has to resolve, and that's going to involve an understanding of what the lower courts did. That's going to help you frame the key issue or issues in the case. I think it's a really good idea to take notes as you read and reread the case. Now, one thing that I do, and you can figure out what works for you, but I've got, I don't know, dozens and dozens of college-ruled notebooks. And whenever I'm working on a project, which is always, I have that college-ruled notebook by my side. And I fill it with notes, thoughts, questions that I have about the case. Sometimes I'll type those questions in the computer and I'll have a lot of files. And there'll be just questions, issues, thoughts. So those might be my files, and I may go back and consult those, and I may go back and look at my written notes, and I very often do that. Now, I may think that I have a really sublime idea, and sometimes I go back and take a look at that idea, and I think, well, that's not going to work. That's a pretty stupid idea. And I think it's really important to do that because it advances the analysis. I kind of think about what Edison said, and Thomas Edison, he was asked if it didn't bother him that he failed so many times and with his inventions, and he said, no, I just found out 10,000 ways that something doesn't work. So keep that in mind. You may start writing, you may think that you've got a really, really brilliant idea, and then you do a little bit more work and realize that it's just not going to work. And sometimes you have to let go of that idea. I've done that literally hundreds of times. But every once in a while, there might be a pearl in there. And if you have that idea, write it down so that you don't forget it as you work your way through the process. Okay, so what do you look for in the case? Obviously, you have to write about it. So what's the key issue in the case? There might be more than one issue, of course. And it doesn't mean that you have to write about every issue, but you want to find an important key issue to write about. And what did the Supreme Court say about that particular issue? How did the court resolve it? Why is it important? Why is it an important issue? Is there a concurring opinion or maybe a dissenting opinion in the case? And that'll tend to sharpen the issue. Majority may take one position and the dissent may take another position. And that may well sharpen how you view that particular case. So the Supreme Court, keep this in mind, Supreme Court took the case for a reason. You might also think about what the reason is that the court took that particular case. Is there a lack of clarity in the law? Is it a brand new issue? Perhaps an issue that the Supreme Court has never faced before? You want to determine if the Supreme Court actually clarified the law. Did the court leave open issues that you might write about? So there are a lot of different things to keep in mind in deciding just exactly what it is that you want to say about the case. Okay. So you've read it, you've worked through the case, you've thought about it, and that's really maybe one of the most important things to do. Think about the case, think deeply about the issues. And note taking really does help. And I highly recommend the notebook process. By the way, there's just something about writing by in longhand that tends to promote analysis. I think more so than, at least for me, that's the case, writing notes on my computer. All right. Now, where do you start? Keep in mind, and I think this is really important, you don't have to have an introduction. You may not know what the introduction looks like until you know what the body of the paper is, what the issue is that you want to talk about, and what the line of analysis is that you want to advance. You may have a theory about the case and you want to advance that theory. Well, until you figure that out, you may not know just exactly what the introduction is. And you may not know exactly what the conclusion is. So concentrate on the body of the opinion. Okay. And then you might start with something that's fairly simple when you write. It's just really critical to keep your feet moving with writing. You might want to write what the case is about, what happened procedurally, and what the issue is on appeal. And then, of course, ultimately, you're going to have to write about the key issues in the case. All right, so some other things that you might keep in mind as you're writing. You see the case, or you read the case, and you reread the case, and again, you're thinking, well, okay, where do I go from here? What do I do? And I don't know if it's writer's block or if it's just that it seems daunting to get started. Somehow you have to sort of crack the process. You have to start writing, but understand that you don't necessarily have to know where you're going with the analysis when you start writing. I think it's really important to know that you can write in segments. And a lot of people do it that way. And then you put the segments together, introduce transitions, and then ultimately you have a law review article. Okay, so keep that in mind. You can break it down. Typically, if I'm writing an article or writing about a particular issue, I'll have literally dozens of separate files. Sometimes, depending on the length of the article, it could be hundreds of files. And it might be an analysis of relevant cases that relate to the issue that I'm writing about. And then sometimes what I end up doing is just putting all of those segments together and then trying to weave them together in a sort of a story that makes some sense. Okay. And here's the notion again. Keep a notebook. Write in that notebook. Take side notes on your computer, whatever makes sense. But most importantly, start writing. Write about something that you understand, something you're familiar with. Don't think that you have to write the whole article all at once. I was told, this is a long time ago, that William Prosser, the great Prosser on torts, would write one page at a time and make that page perfect and then go on to the next one. I don't think that's the way to approach it. Okay. Now footnoting the article. I think that it's important to footnote as you go, because otherwise if you just sort of do a stream of consciousness, I suppose it really depends on how good your memory is. But if you write with a stream of consciousness technique, the analysis may be really good, but it also may be quite frustrating because you may forget what the authority was to support whatever the thought was that you had when you started writing the article. So it's a pretty good idea to keep track of the sources. Maybe that a lot of the sites are to the case that you're going to be writing about, and so just note what the pin side is to that particular case, and then you don't have to go through all of the frustration going back later and then trying to find the citation. That can be really, really annoying. So the footnotes at that point, when you're doing the initial draft, don't have to be in Blue Book form. But all I can say is by the time you submit it, it would be a really good idea to have your footnotes in pristine Blue Book form. Okay. I think it's really important to start early. Once you get the case, start on it right away. Don't wait until the last couple of days. You might be successful, but it's going to be an awful lot harder and you're going to be frustrated. So start early. And then I think an incredibly important thing is that after you have a draft or even part of a draft, rewrite it. You want to really be critical of your own work, and that's really one thing I think that law review experience will do for you. Now, maybe you're at that point already, and you're really, really good at editing your own work, but a lot of people aren't. You write something, you think that's pretty good, and you really don't want to change it, but be critical. I'd say even be hypercritical of whatever it is that you're writing and try to be objective. And as I've said, lots of ideas just don't write. You may have a pet idea that you develop and you try to support it, and no matter what you do, it just doesn't work. Well, let it go and move on to something else. You've learned a lot, again, by finding out, as Edison did, something that didn't work. So don't get frustrated if you have a pet idea and it just doesn't write. Get used to it. It's going to happen lots and lots of times to you. And again, as I say, try to be objective in editing your own work. And it's so important to get started early. You have a limited amount of time. You want to get what you can down in a draft and then re-edit that draft. All right, now, a couple of other things to keep in mind. I've seen lots of student papers that are critical, even hypercritical, about decisions that a particular court might write. Now, just remember, the legal world is a small world, and I sort of think, and I'm placed in a position a lot of times in writing pieces that may be critical of a particular case. But I always ask myself, would I be willing to say this to the judge's face? And I've done that on occasion. So it's I think somewhat easy to say, well, the Supreme Court was just absolutely wrong in this particular case. Oh, really? And why is your opinion better than the court's opinion? Now, maybe it is, and maybe the court missed something and missed a significant issue. But a lot of people have worked on that opinion, some pretty smart law clerks. The opinion is circulated in the Supreme Court. And there may be concurring opinions and dissenting opinions, but if there's a majority opinion, the justices have all agreed on that opinion as that opinion gets circulated. So they've done an awful lot of work on that particular opinion. I remember Paul Anderson telling a group of students that, you might not necessarily know the most about a particular area of the law, but by the time he gets done with a particular case, he's going to know everything that there is to know about that particular case. So a lot of work has gone into that opinion. And so I think you want to think carefully before you really heavily criticize that opinion. You could be interviewing for clerkship with that judge in a year or so. So it's just one thing to keep in mind. And I guess the notion is that And what I would urge you to do is to be measured in the response to the opinion. You're going to have to write something about the opinion, and might be nice to say that well, the Supreme Court really got it right in this particular case, but that doesn't sound exactly like a thundering conclusion. Justice Holmes once said that it didn't. The one thing he couldn't stand is when people agreed in the journals with something he had written. So you're going to find something about the case to write about. Now, maybe the court left issues open, and so maybe you want to write about those open issues and lines of analysis that the court might pursue. You might suggest, as Haley Ostraker did in her case note, there are alternative ways of looking at the causation issue that might have been superior. It's true that sometimes the court might just be flat out wrong in stating what the law is. And if that's the case, maybe the court's opinion is inconsistent with prior opinions, then you point that out. So there are lots of different ways to go on the issue, but remember, you do want to consider how that criticism might sound to the people who have written that opinion and the people who have worked on that opinion. Okay, so these are some things I think to keep in mind. And then I guess finally, just do it. Once again, you're wondering whether you have the ability to do it. I guess I'd ask, how do you know that you don't? If you don't, try. You'll have time to do it, or at least hopefully you'll have time to do it. And if you can clear the decks as much as possible during the time period when you're working on that article, try to do that. Give yourself space, give yourself time. And if you doubt yourself, all I can say is don't. Just get involved in the process, and you'll find that the writing will come perhaps a lot easier than you thought it might, especially if you start attacking the case and your analysis really in segments. And again, you don't have to sit down and write the whole article all at once, right? Write it in pieces. All right, well, that's pretty much it from my perspective. Now, I don't know if anybody has questions for me or for law review editors who are on the program tonight.
Thank you, Professor Steenson. Sorry. Thank you so much, Professor Steenson. I really appreciate it. Students, you're welcome to put them in the chat or raise your hands and just ask directly. Yeah.
No, I can't see the chat. I probably can stop the screen share, right? Maybe that would make sense at this point. There we go.
Lawrence, I've got a question. Can you speak to, is there a closed universe of sources that goes along with this writing? And can you help us understand, is the purpose, like, are we supposed to synthesize the entire packet of materials that we get? Are we supposed to be selective, or how does that part of it look in practice?
Well, I'll let the editors, I think, answer that. I have my own idea of how it's going to work. Carissa?
It'll be a closed universe, and what we mean by that is that we will provide you with a limited number of sources to use, and you won't actually be allowed to even do any other research. So you don't have research also on your plate. This is just looking through a packet of materials that is going to be much more than you're going to actually use in your paper. But we're going to give you a lot of options, because the idea is that you'll have this one core case, which will be this Minnesota Supreme Court case. But there's so many different arguments or theses that you could have that stem off of that. So We're just trying to give you options and sort of some breadcrumb trails to follow that stem off of that case. So last year, a board member gave the advice that I followed, and I thought it was helpful, which was you need to skim the packet, read the case really, really closely. Like Professor Steenson said, read the lower court opinions really, really closely. But once you start feeling like I maybe have an idea of what I think is significant here, then you can be more discerning about which sources within the big packet you're going to delve into further. Does that make sense? So it's not a synthesis of every source in what could be a packet that just has hundreds of pages in it ultimately, because right, we're trying to give you options. It's not synthesizing all of that. It's you looking for what you think is significant and then picking and choosing the sources in that big packet that you think you really want to use.
And I might add another point about writing. If you see in that packet, and I consciously avoid trying to determine what's in there because I don't want to, if I end up talking to students about writing on it, you can't talk to your professors, by the way, once you get the case for obvious reasons. But I try to remain largely ignorant about the case and those additional materials. But one thing that I mentioned in breaking things down, it may be that in that packet of materials, there are a couple of cases that seem to be really important. Well, you might write about that case. So that's one file. And that may then be introduced into your analysis later on. So that's once you identify in that packet of materials, whatever it looks like, sources that seem to be relevant, then you might write about why you think those sources are relevant. And that can be one file, and that may end up then finding its way into the completed paper that you're writing. I'm not seeing any in the chat.
Yeah, I'm not either. Well, if there are further questions, we welcome them. But if not, are there any questions about the law review write-on process in general?
So let me ask the editors, what's the most important thing, the single most important thing for students in the write-on competition to keep in mind, the one rule or a couple of rules that you would say people should follow?
I think the number one thing is to finish right on. That's what I'll say is it's really important to finish right on. It's the number one reason why people don't get onto right on is they don't, or they get onto law reviews, they don't finish. So if you finish, you are partway there.
I will definitely echo that. It is a big task. Finishing it is the hardest thing to do. I will also say I've been working today on the case file that will be sent to each of you, and it's very big. So please do not get lost in everything that we provide to you. Carissa mentioned this, like skim is really important. We're going to give you the Supreme Court case and the lower court decisions. Know those really well, but everything else, you could easily get lost in it. So just manage your time appropriately so that you don't get lost in what's shaping up to be hundreds of pages worth of material for you to select from, not to be experts on.
Emma?
Oh, hi. Yes, I have a question is regarding, I know that everybody has a different pace, everybody works different, but on average, how much time do you think is needed? On average, like how much time do you think is needed to complete this task?
I'm going to give my number and then maybe if other board members want to correct. I'd say to write the case note, it is about 20 hours. And that will, again, depend on you, but it's about 20 hours, I would say.
Yeah, I think
20 hours after you have read the whole material.
Well, yes, but it's like, so I guess to kind of, I would say I also spent about 20 to 25 hours on it, but that first chunk was a lot of reading, just like being familiar with it, reading the case, rereading the case, third time, fourth time, because the case we wrote about last year had some complexities that I was not personally familiar with. So I had to take a lot of extra time to kind of dig into the case file specifically. And then I started to generate ideas, and the writing process probably took about 20 hours.
Thank you.
Carissa, yeah, you can just go
I
ahead.
would just say, kind of going off of what Steve said and what Professor Steenson said, just I would start the first week. I would not wait till the second week of write-on to get started, even if it only takes you, let's say, 20 or 25 hours. And I say that because I think my number one tip, besides being discerning about the sources in the packet, is to give yourself plenty of time to just, like Professor Steenson said, like think about the case. And that sounds maybe kind of vague, but you kind of need some time to digest it and think about what's being said, because there are multiple things that are being said in the case. And I think that as spend enough time up front thinking about it and taking notes on it, and skimming the sources that you can find a good path to go in, because the more work that you put in at the front, it actually makes the writing process go a lot faster. So my tip is just don't be afraid to feel like you're sitting on it for a while, because that's kind of how I felt in my first week last year. Was I was like really just looking at the sources and looking at the main opinions really, really closely. And I didn't really get into really pen to paper seriously until week 2, but I had done a lot of thinking and outlining in week 1. So then week 2, the writing was actually, it went better, I think. So don't feel bad about spending a lot of time up front.
Sophie.
I want to answer both the timing piece, or speak to both the timing piece, and then also get to a couple of the questions in the chat. As to the timing, I agree that you should start thinking about it. This is also something that you can do even if you are working full-time. We do have a lot of people who are working full-time while they're doing write-on, so it is very feasible. And yes, it takes some finagling with your schedule and you have to carve out time, but it is doable. I will also say it is, if you can work on it that first week, like Carissa was saying, both for that reason to think it through, but also you might have something come up in the second week of write-on that might throw off your schedule. I know somebody who wrote on one year who had an obligation the first week, was planning to write the second week, and got COVID. And they still completed write-on, but it really threw off their schedule. So you can do it. It takes a little bit of planning, but it's absolutely feasible, again, even if you are in the midst of a full-time job. And then for the questions in the chat, I see that Stephen answered the due date question. And then there was also a question about the structure to follow. And we do provide you with a structure to follow. It is in the handbook that goes out. But for Stephen, Theo, Carissa, is that something we should speak to now? And I don't know if Professor Steenson, if you're prepared to talk about that, or if you would like one of us to handle it.
Like the outline? Is that kind of what you mean? Like the outline of a typical case note?
Yes.
Professor Steenson, I think, had Haley's paper up, the table of contents, and I would say that's pretty representative even of what kind of comes out of the write-on process in terms of like the structure is not like IRAC. I think that was the question in the chat. It's not really like that. It's so I think it is a good idea to look at Haley's note and the table of contents in Haley's note, because it's more like you'll have an introduction where you're kind of introduce what your argument is, maybe a little bit of background. And for you all, since this is a very abbreviated case note, it's going to be short. You're not going to write a 40-page paper. So you're going to have an introduction, you're going to have a background section kind of on the area of law that the paper is on. You're going to summarize what the Supreme Court did in the opinion that you're writing on. And then the bulk of what really I think matters the most, and this is, you'll be familiar with this, and this is kind of reflected in what we do in other legal writing contexts, I guess, but an analysis, a discussion. What are you saying about what the court got right or wrong and why? And what do you think, like, what do you recommend that they could have been thinking about differently? What's a path that they could have gone down that they didn't? It's kind of how I would summarize it. And the rest of the editors can speak to that too. And then you'll have a conclusion. And I think those are, if I'm remembering right, those are kind of the main sections, but they're represented in most case notes, I would say, that you can find in our published issues of Mitchell Hamlin Law Review. Just note that they'll be much longer when you find them there than what you'll be writing. So feel free to add to that, anybody else, but.
Yeah, in terms of structure, I understand that a lot of people are coming into Write-On as 1Ls, either blended or BAM students, and they have their experience in LARC of writing litigation-focused analysis. And a case note or an article in the law review is not the same. However, you are still using those same skills of analysis in the general sense. It's like Carissa said, you have the structure of an introduction and kind of like a history section or a background section. If it helps, you can think of that as analogous to the R in IRAC, where you're kind of setting the stage, you're setting the foundation of what you're actually going to write about. And then you're going to go into your analysis and you're saying, okay, I set out this series of events legally. What does it mean in the context of this case? Why did the court make this decision? What do I think about it? Do I disagree with their decision or whatnot? I think it is helpful to sort of imagine it as IRAC, but it's not strictly IRAC because we're not in a litigation context. We're writing academically. So we're more focused on history as a foundation for the paper rather than stripping rules out of a case and kind of creating a sort of rule-based structure. I hope that makes some sense.
Kelly? No, hand down. One thing I would highly recommend, and ever since I've started law school, actually, if I'm going to understand a legal rule, whatever it happens to be, I need to know where that rule came from. And so I need to find whatever the rock bottom is. A few years ago, a lot of years ago now, actually, when I started writing about products liability law, specifically in Minnesota, I thought, well, I'll just read every products liability case that's ever been decided, going back to the 1870s. Every one. I will understand every one. It really, really helps if you understand the origins of the rule. And if you do that, and I would assume, and without knowing, that the materials in the packet will give you sources to look at that will help you get to rock bottom. So once you understand the basis for the law, then it's going to be a lot easier for you to determine whether the court analyzed the case the right way. So think about that. You also, I think, will have a much better case note the broader your understanding is of the underlying law. So you just simply want to be facile in understanding that law, even if you don't end up writing about it. In a way, it's sort of like teaching. The very first year that you start teaching, it may be that you're probably going to get across about 95% of what you know, and you may be struggling to stay a week or two ahead of the class. Nobody would actually tell you that, I think. But then later on, a lot of preparation goes to broadening your knowledge and deepening your knowledge. And so eventually, after you've been teaching for a while, the statistics flip. You might get across 5% of what you know, and the rest is sort of a base. And in writing, this is actually, I think, a pretty good analogy in writing fiction. People who teach creative writing will require you to dialogue with your characters. And that gives you a certain amount of depth, even if that depth doesn't necessarily appear in the story that you're writing. It's the same thing with understanding the law, broadening and deepening your knowledge of the basic rules. It'll make you much more facile in dealing with the law. So keep that in mind as you're reading through the case and reading through the authorities that you're provided with.
I just popped some sample write-on case notes that we have on our write-on webpage right now. Those would also be helpful to take a look at, maybe even more helpful than published ones, just because those are more representative probably of the work product that you would have at the end of this process in terms of length and sections and things. So I think those are actually the same ones I remember using and having right next to me the entire 2 weeks I was doing this, because it was very helpful to sort of see how they were piecing this together. So hopefully those are helpful. And for anybody listening later, you can find those linked on our write-on webpage on our website.
Other questions?
Further questions, you can email us from our website, that Mitchell Hamlin, the law review website. We have the mitchellhamlin.submissions@gmail.com is where you can contact notes and comments editors with future questions that come up. And if you haven't registered already for Write On, I will put into the chat in just a moment the link to register. So please do that, and that will just get you the information about how to do Write On. It does not commit you to completing Write On. So yeah, I'm gonna grab that right now.
We'd also like to remind you that we have our third and final session to prepare for Write On next Monday, April 29th. This is our How to Blue Book session. This will be hosted by our managing editors of Volume 51. So that's next Monday, April 29th at 6 to 7 p.m. Central Time, same time slot as what we're in right now. I very well may attend just to learn, because I don't know a lot about Blue Book. And I have every expectation that it's going to be a very helpful session for both write-on applicants and just, legal writers in general. So one last check for questions. All right.
Thank you all. Thank you, Professor Steenson, and thank you other board members who are here.
All right. All I'd say, at least as far as my concluding remarks, is that do it. If you're questioning whether you can do it, do it. It's a wonderful experience. It will stretch, refine, enhance your writing abilities. Is just a tremendous experience, and you all have the ability to do it. Don't doubt yourselves. So again, just get involved, do it, take a crack at it. And good luck.
Thank you very much, Professor Steenson. Thank you all for joining us.
Bye-bye.